Cominciamo. First of all, I would like to thank everybody to be here in presence, and also I would like to say hello to the people connected online. I would like to thank the Ordine dei Consulenti in Proprietà Industriale, with which I organize this conference. In particular, I would like to thank the President of Ordine, Anna Maria Bardone, here in person as well. There are about some hundreds of people connected online now in direct time, and this video will be available in the websites of the Ordine dei Consulenti for the people, for the IP attorneys who would like to have the credits from this conference, because I remember that this conference is valid for 4 credits for the Ordine dei Consulenti in Proprietà Industriale. I would like to start as quickly as possible. First of all, with the greetings of Vice President and Minister for Foreign Affairs, Antonio Tajani. He forwarded to us a message, a written message. Onorevole Tajani ringrazio l'onorevole Billi per aver organizzato questo incontro su un tema di grande interesse per il sistema economico europeo e per le nostre imprese, e rivolgo un saluto cordiale agli esperti e agli ospiti presenti. Pur essendo una competenza di corti specializzate, quella della giurisdizione brevettuale è una materia ben lontana dall'essere una questione tecnica solo per pochi professionisti. Al contrario, la proprietà industriale e la sua tutela sono una delle leve che fanno un paese più competitivo sul piano dell'innovazione tecnologica e un elemento di certezza per le aziende che esportano o che investono all'estero. Un tema al quale, come Ministro anche del Commercio Estero, sono quindi particolarmente sensibile. Ne ho parlato per esempio appena pochi giorni fa a Verona con il Ministro del Commercio cinese, al quale ho riportato le criticità segnalate a proposito di alcune nostre aziende presenti in quel paese. In questo campo, in un'Europa in cui stiamo vivendo un momento di forte accelerazione, dopo una lunga e non sempre facile gestazione, il nuovo sistema brevettuale europeo è partito e con esso il brevetto unitario europeo. È molto positivo come più recenti dati indichino che imprese e operatori della proprietà industriale si stiano già avvalendo di questa nuova opportunità. Perno giurisdizionale del nuovo sistema è il Tribunale Unificato dei Brevetti, che dal prossimo giugno vedrà anche una terza sede nella città di Milano, affiancarsi a quelle di Parigi e Monaco, un risultato non scontato, al quale il governo ha lavorato con grande determinazione. È stata una vittoria del sistema, in stretto gioco di squadra con tutte le istituzioni pubbliche e private. La sede, lo voglio ricordare, sottolinea il Ministro nonché Vice Premier, chiamata a decidere di tutela di brevetti materiali di grande rilevanza per l'industria europea e italiana in particolare, con competenze nei settori farmaceutico, agroindustriale, fitosanitario, della moda e dell'arredamento, tutti ambiti cruciali per un'economia che è la seconda manifattura d'Europa e con una forte vocazione all'export. Sono sicuro che il convegno di oggi, anche grazie alla partecipazione dei rappresentanti del Tribunale Unificato dei Brevetti, sarà un'utile occasione per approfondire ulteriormente il funzionamento del nuovo sistema e le opportunità che esso offre per la promozione dell'innovazione e della crescita dell'Europa e dell'Italia. E quindi il Vice Premier e Ministro conclude augurandoci buon lavoro, Antonio Tajani. Grazie mille. Abbiamo adesso due brevi contributi e saluti del Ministro della Giustizia Nordio e del Vice Ministro al Made in Italy Valentino Valentini. Io pregherei di partire innanzitutto con il video saluto del Ministro Nordio. Grazie mille.
Good morning. I would like to extend my greetings to all of the organizers of this important moment of interaction that provides an opportunity to discuss what we can consider one of the main new elements and achievements in the field of justice of recent years. The designation of Milan as the third seat of the UPC represents a systemic achievement, by no means taken for granted. It is a victory for everyone, a victory that will benefit everyone. Achieving the establishment of the third seat of the UPC in Milan after Paris and Munich represents a strategic milestone. At a time when we are committed to transforming justice, a pillar of every democracy, also into a potential lever of the country's economic growth. The UPC in Milan can become the flagship of a system that is now committed, under the impact of the NRRP, to get rid of chronic criticalities, of backlogs, and excessively length of proceedings. Justice, therefore, can go from being a burden to being an engine of economic growth. While awaiting the inauguration of the third seat of the UPC on July the 1st, the territorial division is already working at full speed, with 8 proceedings already dealt with at the end of November. Milan hosted all the European UPC judges for a training course. At the end of January, the headquarters agreement was also signed, which will be located in Via San Barnaba. Therefore, the UPC stands as a model of the country's ability to team up for a shared and overriding interest. The achievement has its roots in our centuries-old history of inventors. It was a foreign citizen, a German, who was the first beneficiary of a patent in Venice during the Serenissima era, which had a patent protection system, as if to symbolically anticipate the birth of the European system that we celebrate today. More than 2,000 inventors were protected by patents granted to Venetian and foreign citizens since the law came into force. Among these, there was also Galileo Galilei's telescope. The value of patent protection has been valid in the past, opening the door to centuries of scientific and technological innovations, and continues to be valid today in the age of artificial intelligence and technology. With the UPC system, the current fragmentation of the European patent system can be overcome, introducing greater efficiency, lower costs, stronger and more uniform patent protection. The goal is to offer business a simpler alternative to the existing system and a more cost-effective path to patent protection and litigation. The launch of the unified patent system may result in a single market for innovation, which is destined to a milestone for the intellectual property sector at the European level. Strategic assets of enormous significance will be protected, and only for the growth of individual companies but also in terms of the national economy. This is why initiative of this kind, with an international scope, take on even greater significance. In taking leave of you, I wish you all a fruitful discussion. Moni.
Thank you. Now the greetings from Vice Minister of Made in Italy, Valentino Valentini. Thanks.
Cari amici, buongiorno. Ringrazio l'Ordine dei Consulenti in Proprietà Industriale, ringrazio soprattutto l'amico e collega onorevole Billi per aver voluto organizzare un convegno su un tema così importante che riguarda direttamente le attività del mio ministero, che però quest'oggi celebra la prima giornata del Made in Italy, quindi vi sono una serie di impegni un po' sparsi per tutta la penisola che quindi non mi consentono di essere con voi in persona. Detto questo, sappiamo che i benefici derivanti dalla scelta di Milano come sede del Tribunale Unificato dei Brevetti sono molteplici, sono importanti. La genesi di questa scelta, tutto ciò che ci sta dietro e anche certamente lo sforzo diplomatico che è stato fatto dimostrano quanto sia strategico avere questa sede, perché rafforza la nostra posizione come hub di innovazione e di ricerca a livello europeo e può avere un impatto, a mio avviso, diretto e misurabile sull'economia, sulla giustizia brevettuale e sul nostro sistema educativo in generale. Nell'economia, evidentemente, dando un impulso all'attrazione degli investimenti. L'attrattività di un paese, sappiamo, è essere dato da un insieme di fattori e uno di questi è il fatto che nel campo dell'alta tecnologia e delle biotecnologie le multinazionali, le società a capitale estero possono essere attratte dalla possibilità di gestire le proprie questioni legali relativamente ai brevetti direttamente sul posto, riducendo tempi e costi associati. Il beneficio poi evidentemente riguarda anche le nostre imprese, le imprese italiane. La vicinanza al Tribunale offre un vantaggio competitivo unico perché permette di affrontare le violazioni di brevetto in maniera più efficace e a costi ridotti. In terzo luogo, altro fattore evidente è che la presenza del Tribunale porterà a uno sviluppo di competenze specializzate nell'ecosistema educativo e formativo, perché le università, gli istituti di formazione, i centri professionali di Milano hanno già iniziato a implementare corsi specializzati in diritto dei brevetti, attirando studenti internazionali e incrementando quindi la qualità e l'attrattività della nostra offerta educativa, altro elemento che concorre appunto in questo concetto così ampio e variegato che è l'attrattività del nostro paese e la nostra competitività per cercare di avere investimenti esteri. Quindi sono ben felice che si avvii questo percorso col convegno di quest'oggi. Mi spiace non partecipare ai vostri lavori, sono sicuro che l'amico Billi poi mi riporterà, perché è per me stimolo il nostro rapporto, la nostra collaborazione attraverso di lui con tutta la Camera legislativa, perché è uno sforzo corale che stiamo compiendo e comunque il nostro Ministero e io personalmente sono sempre più convinto e sempre più cosciente del fatto che la competitività si gioca su fattori importantissimi, tra cui proprietà intellettuale, tutela della proprietà intellettuale e eliminazioni e streamlining di tutto ciò che può comportare la gestione, tra virgolette, burocratica, l'efficacia della protezione della proprietà intellettuale sarà un fattore, ed è un fattore competitivo fondamentale. Mi scuso ancora per non essere con voi, vi auguro buon lavoro e grazie.
Thanks again, and now the stage for the contribution to Sam Fabrizi, Ministro plenipotenziario della Farnesina, Minister of Foreign Affairs. Prego, Ministro Fabrizi.
Thank you very much. So President Bardone, President Grabinski, dear Klaus, UPC judges and lawyers, ladies and gentlemen, it's a great pleasure for me here to speak on behalf of the Ministry of Foreign Affairs, and a special thanks to Simone Billi, Member of the Parliament, for the organization and invitation at this seminar with stakeholders and to focus on this important topic. So I have 5 minutes in front of me, so I will be very, very quick just to explain a bit some of the tasks that's been given to the Ministry of Foreign Affairs to deal with the two main points regarding the UPC governance, so the establishment of the Milan division and the setting up the relation between the UPC and Italy. So on the first, a bit of background, known to everybody, but just to set the ground, the agreement that established the UPC is dated February 2013. It was signed by 25 members of the European Union. It took 10 years to have the 17 necessary ratification to allow its entry into force on June 1st, 2023. The panel later in the afternoon will go into the detailed reorganization of the UPC, but for the purpose of this presentation, it's sufficient to recall that the UPC is organized around multiple locations and different degrees of jurisdiction: a central division, local and regional division, and an appellate court. Italy decided for the city of Milan to host decided for the city of Milan to host its local section. This in reason of the IP focus of the industry and related services of Lombardy, and the local section is up and running since June the 1st, 2023. More complicated has been reaching the agreement of the central division. Originally, the central division was imagined around the central seat in Paris and two sections in Munich and in London. Following the withdrawal of the UK from the EU, the so-called Brexit, and the withdrawal also from the UPC, the question of the collocation of the seat, originally imagined in London, came to the fore. So we were confronted with a mix of political and legal element to be taken in consideration. On the political side, there was the need to reach a consensus among the 17 participating members of the UPC on maintaining the original structure of the central division centered on 3 seats. Some countries were even ready to acquiesce to what we call a quick fix, so Paris and Munich only, while Italy, on the contrary, proposed to maintain the integrity and the coherence of the system and made the case vis-à-vis its partners, in particular Germany and France, that a second seat of the central division was to be maintained. Italy was entitled to host it, and the city of Milan, that was hosting already a local section, would be the natural candidate. From a legal point of view, it was necessary to amend the UPC treaty, at that time was not yet entered into force, amend it making use of the few existing and never tested the disposition of the treaty regarding the recess of a contracting member, in that case the UK, the establishment of a section in Milan, and the question of his competencies on the case to be heard. The negotiations were not always easy. I won't go into detail, just to say that they took almost 3 years. The negotiations were concluded with the unanimous decision of the administrative committee the UPC governing body, where I sit on behalf of the Ministry of Foreign Affairs, were concluded on June 26, 23rd to amend the treaty to establish the Milan seat of the Central Division, assign to Milan a set of important competencies, particularly in the pharmaceutical sector, together with agribusiness and phytosanitary areas, introduce a review clause in 2026 to assess the workload and the functioning of the Milan section. And we are currently working with the UPC Secretariat and the fellow UPC members to make this decision fully operational, including the selection and appointment of the judges. The second element that was being also referred in the presentation is the headquarters agreement. The UPC is an international organization operating in Italy. In this case, it's a supranational tribunal, and the headquarter agreement is foreseen to ensure the UPC enjoys the best legal and practical condition to settle in and operate in Italy. We are particularly pleased that earlier in January, the Italy UPC headquarters agreement, the first of its kind, was signed at the Ministry of Foreign Affairs, and Dr. Grabinski signed on behalf of the UPC. Now the agreement is in the Parliament for its ratification. So in conclusion, as Vice President Tajani said, the UPC is a policy-oriented tool directed to a wide spectrum of interest and stakeholders. In our view, the creation of a European mechanism for legal resolution on patent, a creation of a European jurisprudence, the cost reduction for business, especially for SMEs, following the start of the unitary patent, a clear juridical intellectual property framework for foreign direct investment are among the key objectives we are striving to obtain through the APC. And also the entry into force of this system bring European cooperation also in the jurisdictional sector to a higher level. Judges, attorneys, practitioners will have a new European-wide horizon. For all this reason, in conclusion, Italy, in line with its spirit as a founding member of the European Union, continues to be at the forefront of the European cooperation, and therefore we are particularly pleased that Milan, together with Paris and Munich, is one of the seats of the Central Division of the UPC. Thank you.
Thank you. Now the contribution of Mirella Delia of the Legislative Office of Minister of Justice. So please, dottoressa Delia.
Ringrazio l'onorevole Billi. Abbiamo ascoltato i saluti del ministro Nordio e per il ministro della Giustizia, appunto, si offrono oggi alcuni dati relativi all'attività che è stata svolta e quell'altra che verrà svolta per l'effettivo funzionamento della terza divisione centrale del Tribunale Unificato dei Brevetti, avente sede in Milano. È un lungo percorso quello che si è snodato dal 1 giugno 2023 con l'entrata in funzione del Tribunale Unificato dei Brevetti. Ed è stato portato così a compimento il cosiddetto pacchetto sul brevetto unitario, che come tutti sapete trae origine da alcuni provvedimenti dell'Unione Europea del 2011 e del 2012 e soprattutto dall'accordo internazionale sottoscritto nel 2013 da 24 Paesi e ratificato ad oggi dall'Italia e da altri 16 Stati membri. Con il brevetto unitario, in sintesi, viene offerta alle imprese un'alternativa, per certi versi più semplice rispetto al sistema delineato dal brevetto europeo, attraverso un percorso più economico per ottenere una privativa industriale e per la risoluzione delle relative controversie. È infatti sufficiente ricordare che con il pagamento di un'unica tassa oggi si può ottenere la protezione dell'invenzione in tutti i paesi che hanno ratificato l'accordo, in acronimo TUB. L'avvio del sistema brevettuale unitario quindi contribuirà certamente al consolidamento del mercato unico, con tutti i benefici economici che possono derivare da un sistema che incoraggia, lo abbiamo sentito, l'innovazione tecnologica e proprio in quanto in grado di proteggere effettivamente in un contesto unitario di tutela unitaria il titolo di proprietà industriale. Il Ministero della Giustizia, in stretto coordinamento con il Ministero degli Esteri, il Ministero delle Imprese e del Made in Italy, il Ministero delle Finanze, ha quindi profuso il massimo impegno per assicurare lo scorso giugno 2023 l'effettivo avvio dei lavori della divisione locale di Milano. Si esprime quindi viva soddisfazione anche per il risultato raggiunto lo giugno scorso con l'emendamento all'accordo del TUB, che ha previsto sostanzialmente l'istituzione della terza sezione della divisione centrale del Tribunale Unificato dei Brevetti con sede a Milano, in luogo di quella londinese, e si è affiancata quindi alla sede centrale di Parigi e a quella di Monaco. Il Ministero della Giustizia vuole quindi qui ribadire l'impegno nell'assicurare il funzionamento della sezione della Divisione Centrale di Milano a partire dal prossimo mese di giugno. E questo perché, come da norme del trattato, la sede dovrà essere operativa entro un anno dal momento in cui è stata istituita. L'Italia quindi metterà a disposizione la sede e il personale amministrativo per un periodo di 7 anni. E metterà a disposizione del TUB, a titolo gratuito, quale sede permanente della divisione dell'organismo in Italia, i locali che sono stati individuati nell'allegato 1 dell'accordo. Si tratta quindi dei locali siti in Milano, via San Barnaba numero 50, un immobile di proprietà comunale utilizzato anche dagli uffici giudiziari. Viene stimato un impegno finanziario di 200.000 euro, una tantum per il 2024, per assicurare la piena operatività della sezione della divisione centrale. Sono a carico del Ministero di Giustizia anche un contributo forfettario in favore del Comune di Milano, in quanto soggetto proprietario dell'immobile e titolare degli interventi di manutenzione. E a tal fine è stata autorizzata la spesa quantificata in maniera forfettaria per euro 20.000 annui a decorrere dal 2024 e le spese di gestione e funzionamento delle divisioni italiane del TUB per un importo complessivo di 150.000 euro annui. Infine l'Italia si è resa ampiamente disponibile ad ospitare le attività di formazione, fornendo anche in questo caso tutte le necessarie strutture. Concludo così e vi ringrazio per l'attenzione e auguro a tutti un buon lavoro.
Thanks, Dottoressa Delia. Now the contribution of Anna Maria Bardone, the President of Ordine dei Consulenti in Proprietà Industriale, with which I organize this conference. So please, Anna Maria.
Thank you. Dear colleagues, distinguished authorities and esteemed participants, it's a great honor and privilege for me to extend my greetings to you on this important occasion. In my capacity as President of the Institute of Italian Industrial Property Attorneys. First and foremost, I would like to express my gratitude for your presence here today, which demonstrates your commitment and interest in the realm of industrial property, as well as in the crucial topics on the Unified Patent Court. The recognition we enjoy under Article 48 of the Unified Patent Agreement is an achievement of which we are extremely proud. Such a recognition not only reaffirms the importance of our professional role, but also underscores the trust and esteem of the institution in our competence and ability to represent the interests of our clients and the community in the complex legal landscape of intellectual property. The Unified Patent Court represents a significant step towards greater harmonization and effectiveness in European patent judiciary system. It's an opportunity that urges us to work with even greater commitment and dedication to ensure that intellectual property rights are protected fairly and effectively. In this context, I would like to emphasize the importance of collaboration and synergy among all stakeholders involved in the field of industrial property. Only through constructive dialogue and shared commitment can we address the challenges and seize the opportunity presented by the increasingly complex and dynamic landscape of intellectual property. In conclusion, I hope that this conference will be a valuable opportunity to enrich our knowledge, strengthen our professional networks, and reaffirm our common commitment to be better protect and promote industrial property. Thank you all once again for your valued presence and valuable participation. Thank you.
Thank you, Anna Maria. After this institutional introduction, we will change the stage. So thanks again to Minister Tajani for his greetings, to Minister of Justice Nordio from Valentina Valentini, Vice President, and thanks to the speakers here in person, Sam Fabrizi, Mirella Delia, and Anna Maria Bardone. Please change your seat, and for the next one, the panel that we call panel number 1. So we have Klaus Grabinski that I will present to you in a few minutes. Please, Paolo Catallozzi, Massimo Scuffi, and Paolo Markovina. We will change also. Thank you again. Thank you. Thank you. Anna, le mani, Le mani. Sì. Prego. Thank you again. Le mani. Sì. Oh, grazie Daniele. Oh, sì. Ci siamo? Dove
No, io metto. Lei dov'è? Si mette al centro, probabilmente.
Di qua. Penso sia quello laggiù, c'è il cavaliere. No, in fondo, sì, penso sia in fondo. C'è il cavaliere col nome, prego.
Ah, ecco il cavaliere, sì, allora di voi.
Prego. Sì, tu. So thanks again to Klaus Grabinski. He was available to participate in person to our conference. He came directly from Germany. And very quickly, introduction of the president of the Unified Patent Court, but not only. He held a number of judicial roles, including as a presiding judge of a patent litigation division at the Düsseldorf Regional Court, and as a judge at the Düsseldorf Higher Regional Court, and also the German Federal Court of Justice. He was an external legally qualified member of the enlarged Board of Appeal of the European Patent Office, and now, as I told you before, he's also the president of the Court of Appeal and chairperson of the Presidium of the Unified Patent Court. So thanks again, Klaus Grabinski, for your availability to stay here at this conference in person today. Thanks. And the stage is yours.
Member of Parliament Simone, Billi, thank you very much for having made this event possible. I think it is a wonderful platform for the UPC to talk about different aspects 9 months, 10 months after up and running. So to lean back a bit and focus on certain aspects. I'm also very much impressed by the support the UPC gets, in particular here in Italy, from the side of the Foreign Ministry, from the side of the Ministry of Justice, but also, of course, from the side of the stakeholders and users. And I think you, Mrs. Bardone, you are kind of representing this group. And of course, I'm also surrounded by friends, colleagues from the UPC, legally qualified judge, Paolo Catallozzi, also a member of the advisory committee, Mr. Massimo Scuffi, and also from your side. Thank you very much for being here all together on this panel, and hopefully we will have a very interesting and fruitful discussion. After a few words of explanation, of course, from my side. You see, it says 9 months up and running. Actually, we are already 10 months up and running, so we are making progress. And my talk will essentially focus on two aspects. So, giving you an update of what happened since the court became operational, and secondly, focusing a bit on the money. So litigation costs and also court fees. So starting with the first part of my talk, which is supposed to take no longer than 30 minutes. I already used 3-4 minutes of it. So coming to Rome, I think it is always good to look at least for 1-2 minutes back. And why is the UPC there? Why do we need another court? Another European institution? And if you look back to the situation before the court became up and running, so before 1st of June 2023, and looking very much back to 1977, there the situation was, patent protection was really country by country. So patents were granted by national patent offices in Europe. So Italian patent from the Italian office, a French patent from the French office, and so on. And of course, this was a problem, in becoming more and more a problem, because there was a single market being set up. At this point of time, only 6 countries, the founding countries of the EU. But of course, nowadays we're already with 27. So the idea was also to get patents on a European level rather than on the national level. And the first important step in that regard, of course, was the setting up of the European Patent Office, and which had the authority to grant, in a centralized procedure, European patents. And this is wonderful, one-stop shop only. You go to one office and you get potentially protection for almost all European countries, so nowadays 38 contracting states, including all 27 EU member states. So that's wonderful. However, what comes out of it is, that was too much. After this centralized procedure is a European patent, and the European patent gives you protection in each of the contracting member states like a national patent. And there you are again on the country by country, state by state basis. And this goes in two directions, mainly two aspects. The one is that a European patent has to be validated and maintained in each EPC contracting state. So this means you have to have contact with each of these patent offices and come back every year, pay the fee again, and in order to maintain patent protection. That's the one side, but the other side is also about enforcement. Because essentially, there are some exceptions, but I'm not going into details. Essentially, the patent has to be enforced country by country, based on the jurisdiction of the European Court of Justice. I only mentioned the case Catallozzi. And so, up to grant, it is one stop only, but after grant, it becomes again a country by country situation. And that's why the UPC is there, and that's why unitary protection is there. And how did the landscape change since of 1st of June 2023? So, of course, it was the agreement of the Unified Patent Code that came into force, and at the same time the regulations that provide for unitary patent protection. And how does it boil down to, first of all, a unitary patent protection? Now, it is no longer necessary for those who want to have unitary patent protection to go from one patent office to the other, but just has to deal with only one patent office, which is the European Patent Office. So this reduces complexity and also lowers cost. If you go to the website of the European Patent Office, they make a comparative study. They provide for a comparative study in which they show that as soon as you want to have patent protection in more than 3 contracting member states, the cost for unitary patent protection is lower than having protection in 4 or more contracting member states on the basis of the classical European patent country-by-country approach. And this, at least seems to me, has been understood by, is always understood by a growing number of users. As you can see, the numbers since the system has come into up and running, so 1st of June, in 2023, the amount, the part of the percentage of the of unitary protection was already 17.5%. So almost every 5th patent was a unitary patent that was granted, and in 2024, so the first 3 months, if you look at the first 3 months, it is almost every 4th patent that is now unitary patent is a unitary patent. So that shows that it is more and more accepted by the users. Now we move on to the Unified Patent Court, and as you know, the agreement has been ratified by 17 EU member states. You see all of them, including Italy, of course. But the perspective is also promising. Romania, which has not ratified yet, in Parliament there has been a voting in favor of a ratification, so it's expected to happen soon. When you look at Ireland, the plans, and this was when I drafted this slide, the plan of the government, and to my understanding still is, at least officially, that a referendum will be held in June 2024 at the occasion of the 2024 European Parliament election. However, when you look into the newspapers, when you read the newspapers of last Friday, it tells you that the Irish government is contemplating a postponement of the referendum, and you may ask why, and the background is that there was a referendum just a few months ago and nothing to do with patents. It was a completely different story about family and care law, and this referendum was not successful, and that, according to this press information from Irish press, is now the reason why the Irish government is thinking of a postponement. But this is we will see how this will develop. It's clearly a matter to be decided by the Irish government and by Ireland. Okay, move on. Unified Patent Court, as you all know, has jurisdiction on unitary patents, also of course on the classical bundle patent, the classical European patents, provided they have not been opted out. And if you look at the numbers of opt-outs, you can more or less say it is about a third of all potential European patents, classical European patents, or published European patent applications that have been opted out. But this leaves 2/3 under the jurisdiction of the Unified Patent Court. Move on, that's the structure of the UPC. You are familiar with this. You have the Court of First Instance with the central division, the local and the regional divisions, and as already mentioned today a couple of times, and this is very important for the UPC. The UPC will have a second section of the central division as of end of June this year, located in Milan, and this section will have the competence on cases concerning European patents of the A classification, which says human necessity, but essentially means pharmaceuticals. And when you look at the number of revocation cases that currently have to be brought to the Paris seat of the central division, you will see that this is an important share of all the cases that have been brought to the central division, and that's a seat in Paris, and that's going to have to be brought as of end of June to the then section in Milan. Another point, of course, worth to mention is the Patent Mediation Arbitration Center. It is not yet there, but it is going to happen soon. The administrative committee is working and doing all the necessary preparation in that regard. And that, of course, is also important in the context of the SAP draft regulation, but I'm not going into details in that regard either. Let's move on. Here you see the full picture. When you look at the map, you see the dark blue EU member states that are the contracting member states of the UPC, and maybe one more number is important for users and stakeholders. With these countries, you cover roughly 3/4 of the gross national product in the EU. So we are quite close to covering the market, but of course 1/4 is still missing. These are the current numbers as of 1st of April of this year of the cases, and this is, you see that the system is used. 169 cases in the first 10 months, which I think is remarkable. And also 46 counterclaims for revocation. So the 46 means in 46 infringement cases, counterclaims for revocation have been filed. The 142 means in cases where there were more than one defendant infringement cases, that tells you the number of defendants that have filed a counterclaim for revocation, but from a procedural law point of view, only one counterclaim for each infringement case has to be counted. Now, this was my first part. I don't know how much time I still have, but now we... some of you still may know the Monty Python from the UK, and now something completely different is coming. Okay. So 10 minutes. Okay, good. Thank you. So the first point I want to cover, sorry, this was a bit moving too fast, is, sorry about this. Okay, first point is court fees. When you look at the contracting member states of the UPC, you see some countries where people who use the patent court system almost pay only a symbolic fee. And at the other end, like Germany, you pay quite a significant court fee. And the UPC is a kind of compromise. You pay court fees, but when you compare it to the German system, you don't pay as much as you would have to pay in the German system. On the other hand, when you read the UPC agreement, it tells you the court share is expected to be self-financing someday. Of course, it can only be self-financing if you have rather high court fees. At the moment, I don't expect the court to become self-financing very soon. However, one more remark in that regard, one should always keep in mind also the money the contracting states get from the fees that are paid for the maintenance of the unitary patents. And if you also take this amount of money into consideration and the fees, at the moment the court is almost self-financing. That's interesting. But of course the court at the moment only pays for its judges and for central function like IT. It does not pay for the staff, which is currently paid for by the contracting member states. Okay, court fees have to be paid in advance unless otherwise provided for, and then the court fees can be fixed fees or it can be value-based fees. And to tell you how it works, in the most important case of an action for infringement, if the value of a case is 1 million, the fixed fee is 11,000. It's always 11,000 in an infringement case. But then you look at the value of action and it tells you, okay, you have to add 4,000. So total fee is 15,000. While when it comes to a value of action of 10 million, then it's 11,000 again, the fixed fee, but then it have a much more important amount to pay as additional value-based fees, and then it would be 76,000 euro. That's how it works. A different, however, action for a revocation, where you always only have to pay 20,000 euro. And if the counterclaim for revocation, then it cannot be more than 20,000 euro. and the concrete fee depends on the fee that is to paid for the infringement action. How to determine the value of action? Essentially, it goes along the lines of a license fee that would have to be paid. So a license fee, when you look at to the past, but also when you look to the future. So meaning when you look for the claim for damages, that's the past, and when you look for injunction for the future. And normally, you don't have to go into details, because the practice, at least as we know it from the German system, is that parties agree on the value of litigation. So the one party says, okay, the value of litigation is 10 million, and then normally the other party has, of course, the opportunity to comment on this, but very often they do not comment, and then it's a 10 million, unless the court has reason to believe it should be more, much more, or much less. Legal aid, also available, I'm not going to details. Reduction of court fees, available for small enterprises and micro enterprises. Reimbursement of court fees can be if it is a company of which the economic assistance is threatened. Reimbursement of court fees possible when the case is either withdrawn or settled during the proceedings, and depending on the time when it happens. So you get a large reimbursement when it happens already in the written procedure. So the first part is happening in the interim procedure, the reimbursement is lower, and if only happening last minute, then of course you get only a small reimbursement. Legal costs, that's another issue. And as you are all aware of, as it's European law, it's provided for in the directive, in the enforcement directive. In Europe, we have the principle of legal cost shifting, which means the party, the unsuccessful party, has to reimburse the successful party for reasonable and proportional legal costs. And when you look into the agreement, it tells you up to a ceiling set in accordance with the rules of procedure. And how does it work in practice? Here you see the ceiling. So again, what matters is the value of litigation. So when the value of litigation is, for example, 1 million euro, then the ceiling for recoverable costs is 112,000 euro. Which means, of course, it's a ceiling. It doesn't mean necessarily that this is the costs that are going to be reimbursed. It can be much lower. It can be just middle ground. It can be just half of it, depending on the situation. But still, it is for the courts to develop an approach to this within the framework of the rules and the agreement. And so, one example is always important for the representatives. You will know it from as a patent attorney, and also the lawyers will know it. Your client wants to know, okay, what is the cost risk? What is going to happen if I lose the case? What money I'm going to spend in this situation? And just to give you one example case, value of proceedings. So first look at the infringement action. Assume the value of litigation is 1 million. Look at the counterclaim for revocation. Assume it is 1,250,000 euro. Then, of course, the court fees are at issue, 11,000. Fixed fee plus 4,000 value-based fee means 15,000 in total. Counterclaim for revocation, it is the same, 15,000. So total cost risk as to court fees is 30,000 euro. So when the claimant wins the case, then the defendant has to reimburse the respective court fee. Recoverable representation costs. Now you add the two value of litigations, which means 2,250,000 euro, and recoverable representation cost then would be up to 400,000 euro, which of course is the ceiling, which doesn't mean that the recoverable representation costs are 400,000, it could be much less. And of course also reimbursement of extra costs like costs for experts and translations. And there, I'm almost there. Just move one more. Okay, sorry. Now it's. This is my final slide, and you see different buildings, and these are different local divisions, central divisions. Do you have anyone here in the room has an idea which the first building is? No, the first one, the castle-like.
Maybe your house?
No. I'm not the owner of a castle. I'm a humble judge. No, it is the regional division in Stockholm, and the office of the pattern of the regional division essentially is in the tower. I've been there once, and it's interesting to see. Okay, you know the next building? Where is it in Europe? We do a little tour of Europe now. It's Vienna. It's a Vienna local division. And then one more, you can see it only half of it now, but that's Düsseldorf local division. And the next one, you know, I guess, the second line, Paris, yes. But I have to say, this is not the official building of the Paris local and central division, but it is a look from the local and central. But it tells you two things. It is very much in the center of Paris, and they also use courtrooms in the court buildings on Ile la Cité. So it is not the office, but the court rooms. And the next one, Minister Fabrizi, you know. Yes. So that's the Court of Appeal in Luxembourg. It's a former parliament building, but it is no longer used as a parliament building of the EU Parliament. And of course, the last one is clear. It's in Milan. At the moment, a local division, but in the future, local and central division of the UPC. Thank you very much for your attention.
So thank you, President Klaus Grabinski. Thank you so much. And now I leave the stage to Paolo Catallozzi, giudice della Corte di Cassazione, nonché UPC judge. So please, Paolo, the stage is yours.
Thank you. I have a very brief presentation. If I can. Okay. Well, thank you. First of all, I also want to thank Mr. Billi for organizing such a conference. Actually, I think it's one of the first conferences, if not the first, held in Rome. So, as a Roman, I really appreciate that. And also in such a nice premises or prestigious premises, and with so many professionals as panelists and attendees. Well, the topic I've been assigned to is quite technical, the comparison with national procedures. So comparison between the procedures before the UPC and the national procedures. Well, before addressing in detail this topic, I think it is important to have in mind some factors, some important factors that play a role in have played a role in drafting the rules before UPC. The first factor is that the rules of the procedures that we apply before UPC is the result of the merger or principle of different national procedural rules. That means that the choice that has been made was not to adopt a national procedural system, rather than to pick principles of different national systems that were deemed to be more appropriate. So that leads to the fact that we have a completely new sets of rules, and especially the difficulties for us is that we have no case law to refer to. That's the first factor. A second factor is that the UPC is an international court with few locations in a very large territory. Klaus mentioned about the fact that territory covers a huge part, 3/4 of the gross production, but also it covers a very large territory in terms of, squares. And the choice, not seldom professional parties have to make long trips to reach the court premises, so the rules that have been drafted favor a written predicts rather than the oral predicts, as well as electronic lodging of those pleadings and the evidence. That's to avoid lengthy working trip for professionals. But also, the written center procedural system to meet an efficiency principle as well, avoiding cost and waste of time related to judges' commutes from national place of work to UPC place of work. So it favors written consultation of the parties, and when it is deemed appropriate to have a hearing, it favors remotely held hearings. Well, also, I misclick. Also, we have to take into consideration the fact that UPC judges are almost every UPC judge, except for notable exception, Mr. Grabinski, are part-time judges, so they have to combine their national work with the work before UPC. So that's another factor that probably has taken into account in drafting the procedural rules. Another important factors is that the rules of procedures are specifically designed for patent litigation, while national rules, at least Italian national rules, are general and apply to all civil proceedings, save for some exceptions. The only common grounds, if I may say, is the provision that comes from the transposition of Enforcement Directive of 2004, which describes some measures, procedures, and remedies that are enforced in Italy as well as in other European countries, and also in the procedural rules that apply before UPC. And that comes to the fact that the difficulty the national judge faced in addressing some topics, and they rely to some, they have to establish, and still establishment, a case law to address some procedural issues arise from the specificity of patent litigation with respect to the general civil proceedings. For example, how to handle the request to amend the patent. We don't have in our national system specific rules to address this issue that is frequent in the patent litigation. Also, I may refer to one of the issues that we face when I was a judge in a national court, how to keep confidential some information upon a request of the parties. So these are the factors that we have to keep in mind before going into details in analyzing and detecting the differences between the Italian national system and the procedures rules before UPC. So the first main difference, we're going to carry out the assessment of differences and similarities between the two systems, and my intention is just to underline some common aspects from a general perspective. I would say from a structural, if not philosophical way, we have not the time to go into details. So the first point is that in Italy we have two different type of trials based on the complexity of the case. So we have a default system, I would say, or anyway, we call it an ordinary proceedings, if the case has quite a complexity, and a simplified one if the case is quite simple. In UPC, we don't have this kind of difference, but we have differences based on the action which is filed. So we have proceedings that relate to revocation action, a set of rules that relate to the infringement action, a set of rules that relate with declaration of non-infringement action or for compensation or costs. So we have a specific set of rules depending on which action is filed. We can see some similarities as for the character of the proceedings. I can say that after the reform of this national procedural rules that happened to be approved in 2022, some similarities increased. And this is one of the point, a front-loaded character of the proceedings. We have the exchange of written proceedings before the first hearing, both before UPC and the national judge, with tight deadlines for submissions of written pleadings. I think it's a common character. And also, it is common character the fact that the judge may intervene quite immediately to decide on preliminary issues. It's a general principle, even if it has differentiation between the Italian procedure and the UPC procedures, because in Italy mainly we call it ex officio, so without any, the judge carries out a check on some preliminary issues ex officio without a request by one of the parties. That's different in the UPC, where preliminary issues are addressed by the judge upon request of one of the parties, and mainly is jurisdiction and competence. We have similar rule as for jurisdiction and competence defense, because the judge has to address it quite soon, but it may postpone the decision at the end of, with the merit of the proceedings. The rules appear to be quite similar, but in the practice, I noticed some differences because, the very first practice in UPC is mainly to address the lack of jurisdiction and competence defense immediately by the judge. So, just in one case, if I don't get wrong, the judge decided to postpone the decision with the merit of the case, while in Italy, the common practice is not to address this defense unless the judge found us very well grounded. So the rules are the same, but the practice seems to diverge. Rapid judgments also in UPC in Italy, there is a way to address the judgment that are clearly, manifestly inadmissible or not well grounded without an order, without coming up to a decision at the end of the oral procedures. In Italy, it seems to be wider, because the possibility to have this kind of judgments, also when the action are manifestly grounded. Another character of the UPC proceedings is that it is composed by 3 stages: written, interim, and oral procedures. Also in Italy, we can say we have 3 stages, even if, the first one is quite similar. The second one, the interim procedure, it seems quite different from how evidentiary phase, I call it that way. I don't know if it's correct. Because in our national system, it is quite important and takes quite a lot of time, this stage related to the evidence getting. Especially we have, and we will address later, we have the court expert. In some % of the patent cases, we appoint a court expert, and that takes a lot of time because you have to appoint, to make questions. The court expert has to carry out the task, has to listen to the parties, have to submit them a provisional draft. The judge may ask at the end some clarification and explanation. So there's quite a long stage. And also we are not familiar with a written witness. We prefer, as a tradition, to have to summon the witness at a specific hearing. While in the UPC, if there's a necessity of summon a witness, we should do it at the oral hearing, so in a conclusive hearing. So this seems to be just quite differences, and also the decisional stage. It seems more concentrated before UPC. The main core is the oral hearing, and the decision is immediately after that. In Italy, the oral hearing may lack only upon request of one of the parties. More focus is more centered on written pleadings, also the decisional phase. The reform that we are in Italy pushes the judge rapporteur to a more active role, so it seems more something more familiar with UPC also. It seems to me that UPC judge has more discretionary power, and particularly I would point out a rule that struck me when I read it first, that the judge rapporteur may extend or shorten a time period. That's something that I learned to be quite usual in some jurisdiction. From my experience, it's quite strange, because in Italy, the judge rapporteur may not extend the shortened time period unless very exceptional circumstances. And also, it seems that before UPC, you have a more interaction between the judge rapporteur and the panel before the decisional phase. Of course, that's a main point. The main difference is, I mentioned before, the fact that we rely in Italy on the court expert, but the choice in the UPC is completely different. It's to have a technical qualified judge, I say, on board in the panel. I just wanted to point out some pros and cons. The pros is efficiency. As I mentioned before, there's a shortening of the time, because you don't have to waste time in appointing a court expert, asking them to answer some specific points, and especially all the period that the court expert needs to study the case, to confront with the parties and draft the opinion. There's also, I would say, a better interaction between judges and the technical expert, because you sit in the same panel, so you can have a daily exchange of opinion. I remember one of my first case, there's Elisabetta Papa among us. I did something that probably I shouldn't have done, but very unusual. I just pick up the phone and ask Elisabetta Papa, that at the time I didn't know her, but what does it mean? This sentence that you write in your opinion? Because actually I was not aware of some technical features of the patent, and so I wanted to be sure that I understood her opinion in the correct way. That's something that the TQJ in the panel would avoid. What is the cons? The cons is that the first one, what do we have to involve to ask for the help of TQJ? In general, also on strictly legal issues, or only when there is a technical issues that is irrelevant? And general cons or possible cons that we receive some criticism, we read some criticism, is that possible appearance of lack of impartiality, because technical judges, most of them carry out works in private practice. So some stakeholders raise their eyebrows. Also, the number of the judges in a panel can be a bit strange for us, because in most of the case, or in many cases, we can have an infringement action that is judged by a panel of 4. Usually we are not familiar with panel of a number of 9 judges. I suppose that the president vote is counts double. I don't know. And also we have different judges in appeal proceedings in UPC, because the panel is composed by 5 judges, while in Italy is 3. But probably that's also because the Court of Appeal, in my understanding, before UPC, joins the role of the Italian Court of Appeal, but also of a court of last instance, that in Italy is 5. So we have also, it may be strange that there are specific procedures for compensation for damages at cost decision. In Italy, we used to have everything in the same proceeding. I'm going very well because I do want to respect the timeline that I was just allowed. Well, as to acquire some kind of evidences, we have, as anticipated before, some similarities as to the fact that they refer to principle the Enforcement Directive of 2004. So the order to produce evidence, the order to communicate information, order to preserve evidence, the CC order, and the order for inspection. These are provisions that comes from the Enforcement Directive that the Italian legislator transported in a very accurate way, in a very complete way. So also the rules of procedures take into account those principles. There's no big differences between the two systems. Maybe other countries have more difficulties in getting familiar with this. Also the provisional measure, we are familiar with provisional measures, with ex parte provisional measures also, so there's not a big difference. Another point is the service of the claim. There's quite a big difference because in UPC proceedings, the claim is served by the registry, while in our national system, it is the claimant that has the task to carry out the service of the claim. And that's allow us to understand the difference on the role of the judge, because in Italy the judge has to check that the service procedure was correctly carried out, while in UPC proceedings it is upon the responsibility of the registry, even if he may have an interaction with the judge in an informal way generally, so the issues are solved or addressed quite in advance. I don't want to say anything, just about the Court of Appeal in UPC framework, because we are in presence of the President of the Court of Appeal, but just a very quick point. It is also the last instance judge, so that means that the referral to the ECJ is mandatory, while in Italy the Court of Appeal is not the last instance judge. A big difference that comes from other jurisdiction is that for certain kind of orders other than the ones concerning language, evidence, provisional measures, they may be appealed only with the leave of the judge of the first instance. That's something that reminds us of the British or common law system. This is something that we are not familiar with, or with discretionary review by the judge of the appeal itself. More familiar we are with some default rules, I would say. No suspensive effect, no new request, facts, or evidence, I would say as a general rule, unless there are specific circumstances. In UPC, we have the referral back as, I would say an exception. It's not a general rule, but it's not very clear, or at least I did not understand, when you refer back. In Italy, we are more precise on that. And if when you refer back, you go to another panel or the same panel, it seems open to the Court of Appeal, while in Italy we have a mandatory provision. And also, and that is in line with the fact that the Court of Appeal in UPC proceedings is the last instance judge, it may refer to the full court, something that we have in Italy in the Supreme Court. If the issues raised are very relevant and very important, they can be addressed by a full, an integrated panel of the Supreme Court or the full panel of the Court of Appeal. Last point is to rehearing. We are familiar with the rehearing, even if there are some some differences. For example, the rehearing before UPC, the competent is the Court of Appeal. Well, in Italy is the judge that issue the decision that wants to be reheard. Also, the grounds are not the same. It's more general in the UPC rules. In Italy, we are more precise, and also there are some differences in time period, but I think there's marginal differences. I think that was my last slides. I just wanted to add one thing that I forgot at the beginning. As usual, I have to disclaim that I spoke not on behalf of the Court of First Instance or the UPC or my personal capacity, but I may bring you a message from the President of the Court of First Instance, Madame Florence Boutin, that she was invited. She couldn't be here, but she wanted to greet all of you, and especially she recommended me to say that she is very happy. She's glad that the central division that Milan will have a central division. She's looking forward to the starting of the activity of Milan Central Division. That's it. Thank you.
Oh, thank you, Dr. Catallozzi. Now I will leave the stage to Massimo Scuffi. He's a UPC Advisory Committee and also Commissione dei Ricorsi dell'Ufficio Italiano Brevetti e Marchi, and I would like to thank a lot Massimo Scuffi also because he came from Liguria today, so long trip to arrive here in person. So thank you again, Dr. President Scuffi. Thank you. The stage is yours. Thank you.
Thank you very much. I am a member of the Advisory Committee, so I will talk about organization and recruitment of the judges, with particular reference of technical judges. I think this is the problem you are interested in now. To understand the importance of the technical contribution in the UPC system, which deals with patent litigation, therefore about dispute with a high degree of technicality, it's necessary to do some premises about the judicial organization. The UPC, as you know, consists of one Court of First Instance and one Court of Appeal. The Court of First Instance, multinational, multilanguage, is organized in local and regional division, and Central Division has one seat in Paris and two sections in Munich and Milan. The panel of the Central Division consists of two legally qualified judges and one technical qualified judge. The panel of the Local Division have three legally qualified judges and may optionally add a technically qualified judge. Under certain circumstances, in fact, a technically qualified judge with experience in the field of technology for the patent concern may be added to the panel of the local regional division on request of the parties or where the court considers this appropriate. The Court of Appeal in Luxembourg sits in composition of 5 judges, 3 legally qualified judges and 2 technically qualified judges with qualification and experience in the field of technology concerned. In their equipment, we identify 5 areas, and group of technical judges include in its areas: mechanical, electricity, biotechnology, chemistry, pharma, physics. Legal qualified judge and technically qualified judge work at the same level, form a pool of full-time and part-time judges, and currently, yes, this is to know the percentage. I don't know if exactly the percentage of employment of legally qualified judges ranges from 20% to 50%, except maybe in Germany, Munich, Mannheim, there is position of 100%. Is correct?
Yes, also Paris. Also, they are also 100% judges.
Yes, yes. All these judges of the pool are visiting judges and rotate among various locations according to the choice of the president of the court, based on the legal and technical expertise, linguistic skill, relevant experience, and obviously actual needs of the case. As you see, from this concise organizational framework, the efficiency of such system presupposes high quality and experience of the member of the panels. For this reason, the recruitment has been particularly severe. The advisory committee had the task of evaluating the application of the candidates, providing opinions on the suitability of candidates, recommended to the administrative committee those deemed most suitable. We have a different gradation: less suitable, suitable, and most suitable, particularly suitable, to recommend to the administrative committee, because we give an opinion and then the administrative committee appoint the judge if they agree with our opinion. The advisory committee studied the application on the basis of the form presented with the CV of each candidate and current job position, proceed to the interviews according to the approved guidelines in order to obtain the feedback on the real experience with patent litigation and technology, linguistic capability, basic knowledge of EPC system, but above all, to know the habituality of collegial discussion and relationship between legal and technical contribution to the decision. A kind of, can I say, an aptitude test to assess the ability to work in a multi-language team. And this is very important for all. The administrative committee appointed in 2022, during the first round, 85 judges, 35 legal and 50 technical. However, this judicial body is destined to increase. It is increasing with new recruitments in view of covering the vacation. There is also a reserve list to identify the most suitable, and the reason of this vacation is the litigation expands and the establishment of a new central, and there is the establishment of the new central division in Milan. So are necessary new candidates and new members. We notice that during the selection, that many candidates had a great experience, which made them particularly suitable for a position as technical qualified judges. I am referring, for instance, to the Italian candidates, which have extensive experience as court-appointed expert in patent dispute, where are called to give an opinion on patent infringement or validity. I refer to the candidates who were technically judges in their country, not in Italy, but other countries like Germany, maybe Denmark, where there is a technical judge. So we preferred these positions. The candidate working also at EPO as an EPO examiner, but retired, or that have promised to retire, because is still active, would be considered incompatible with the function of an UPC judge. On other point of view, we notice this excellence and you propose for nomination. But the real problem was that this system, there is a problem that many candidates had a great experience. Yes, okay. But there were some position which may be incompatible with the UPC system for their work position. I mean, when you decide, especially in the second round, to select the judges, we try to put aside all the candidates who are in private practice in order to be sure of the absence of possible conflicts of interest due to activities as a private practitioners or employment for a company. It must be remembered that UPC has to be perceived as a code totally neutral. So, in the respect of the Code of Conduct and its ethical rule we approved just last year, it is always necessary to guarantee impartiality and independence of its member. The problem doesn't exist for full-time judges who may not engage in other occupation or external occupation except for the exercise of other judicial function at the national level. But on the contrary, part-time judge, in general technical judge, can exercise other functions, provided there is no conflict of interest, even potential. For example, technical judge cannot act as representative before the same court where was appointed or give legal advice in a case pending, or when dispute pertain to the validity of infringement of a patent filed by his firm. I want to remark that the UPC system recognized the right of audience to the European patent attorney, entitled to act on the same level and in the full powers of a lawyer as professional representative before UPC, as long as equipped of appropriate qualifications. There is only one difference between the lawyers and then patent attorneys. Parties may be represented only by lawyers authorized to practice before a court of contracted member state, while such limitation you don't see envisaged for patent attorney provide for such European qualification. Is more qualified the patent attorney than the lawyers at the moment. However, the patent attorney and the lawyer have the same right of representation and the same role before the court. But they cannot, as I see, at the same time as part-time judge in company where they work and company where that are directly or indirectly involved in the proceeding. There was also another problem, the publicity promoting, because the judgment must always prevent the firm, but maybe this is also in the code of conduct of the consultant, must only prevent the firm where he works from using his position at the court as means of promoting his business of interest. We suggested also that president of the court should not appoint a technical judge in the local division of the county of its residence, or where his company is based in contiguous territorial districts, in order to interrupt every also apparent connection, source of potential conflict of interest. Anyway, of course, I think that is necessary serious investigation, because we have to avoid the conflict of interest, but we have not to avoid the exercise of private activity, because this is possible. The problem is to see the border. You see, if maybe it is possible, it's this conflict of interest, or and in this case, I suppose there is an help by the method of abstention and recusation of the party. So we provide for equipment, and you must be severe also to select only those we are certain there is no conflict of interest. But maybe they, if are if they would are nominated in the court, if they are in front of a conflict of interest, because, for example, they are called to decide about a litigation concerned the firm, or they just provide a legal assistance. Of course, I think he have to abstain in this case, because there is a sort of a certain incompatibility of all. In this position. But as I said, we were severe on this point. This was very difficult to identify exactly, you see, because there are a lot of position, a lot of control to do on the written documents. But we have the possibility, a larger selection at the moment. We select only those that, in my opinion, it was not probable a conflict of interest in such terms. Anyway, with all these mentioned precautions, in conclusion, it can be said that the system has exalted the figure of the technical consultant, in line with the highest quality of legal proceeding in Europe. The professionist, the patent attorney, maintain the proper role of expert appointed by the court when it's necessary to gain a technical opinion, in particular complex case, where the qualification of judge is not sufficient and they require further more specific technical support. He can operate and decide as a technical judge in the UPC panel side by side the legal judge, with the limit of the conflict of interest. He is authorized to defend the party side by side the lawyer, acting as patent attorney. And finally, I think that this professionalist could maybe aspire also to be included in the list of the mediators arbitrators, according to the criteria and qualification still to be determined by the Patent Mediation Arbitration Center. You know, this is a center, independent body, that operates in close contact and cooperation with the court, and I think that the possibility to be included in the future list of the patent attorney, that is a specialist in also in the definition of the litigation, I think is a further opportunity that serve to reinforce the importance of the patent attorney and his technical contribution. Thank you for their attention.
Thank you again, Dr. Scuffi. And I see online Professor Cesare Galli ready for his contribution. A quick introduction. Cesare Galli is a full professor on intellectual property law at the University of Parma. So thanks again, Professor Galli, for your availability, and the stage is yours. Thank you.
Thanks again. In turn, I must join in thanking Mr. Billi and all the organizers of this conference, the distinguished speakers, and before that and foremost, all those who had the foresight to imagine this new system of patent protection and litigation, which puts Europe, our true and great homeland, at the forefront of innovation, both technical and legal. The reduction of patenting costs and also judicial protection costs for transnational litigations will most likely allow to free resources to do and defend innovation, allowing to react more strongly to the violation of the rights. If nowadays, or rather before the entering into force of a new system, the patent owner based the judicial disputes for infringement of a larger market criterions, with a new mechanism, it will be more convenient to attack in the producing states, and Italy may become a very competitive venue for infringement claims before the UPC, especially considering the great experience of our judges. Of course, during the transitory period, the case might still be brought before the national courts. We will have competition between the national courts on one side and the UPC on the other side. Competition is positive, generally speaking, because it favors efficiency and tend to encourage best practices and good results for the parties. However, companies and law firms, at least in this transitional period, will face more complexity, new challenges, and new enforcement strategies. It is on these strategic issues I would briefly like to focus from a business-oriented perspective. You know, I am at the same time an expert for the Italian government for the EU Observatory on the Infringement of IP Rights, a professor, but also practicing lawyer. And so let me have a view on the need of the industry in my short speech. The starting point is, of course, Article 83 of the agreement, which regulates the transitional regimes, the conditions for opting out and also for opting in. Although a recent ruling by the Helsinki Legal Division of the UPC, based on a strictly literal interpretation of the rule, made it clear that the space for the letter for opting in is narrow. Unless this position is reconsidered, what I strongly recommend, it will create problems for companies that have opted out in the sunrise period indiscriminately, all their patents, just to stand at the window. A bad strategy from my point of view, but it's a pity that we do not favor them to come again in the system. Anyway, Article 83 attributes to the concurrent jurisdiction or exclusive in case of opt-out of the domestic courts of the member states the actions for infringement or for revocation, without mentioning either action for declaration of non-infringement or urgency actions, which, at least in the Italian system, include also non-infringement urgency actions. But in this case, frankly speaking, it seems clear to me that the expression, apart from its literal meaning, is all-encompassing. All the case should be, in case the patent has not been opted out, either brought before the UPC or before the National Court. In this regard, it should be noted that preliminary injunction or seizure actions brought before the domestic courts may also concern national fractions of a European patent other than and in addition to those of the countries adhering to the UPC system. Of course, insofar as the National Court has a right of jurisdiction to hear them on the basis of the applicable rules of private international law, and therefore, first and foremost, the Brussels I regulation and the Lugano Convention. Perhaps also the UPC may be given such a power. Yes, Article 34 of the agreement seems to limit the competence of the UPC in the case of a European patent to the territory of those contracting member states for which the European patent has effect, considering the countries that adhered to the courts. But at the same time, Article 31, international jurisdiction, specifies that also the UPC jurisdiction shall be established in accordance with the regulation Brussels I. Therefore, it seems indicated that in reality the Unified Court may also hear these further fractions of the patent within the limits in which this is possible for the internal judge of the member states, which is entirely logical if one considers that the UPC is a national judge, is a transnational national judge, but it's not a EU judge from this point of view. And this possibility is particularly important if we think to the case law of the European Court of Justice concerning the possibility of bringing cross-border actions, at least in preliminary injunction proceedings, irrespective of the fact that in this case, in incidental way, also the validity of a fraction of the European patent other than discussed before the national court seized should be considered. That, according to the famous Solvay decision of the European Court of Justice of 2012 in the case C616 of 2010. By the way, that means in Italy also torpedo non-infringement urgency actions. Of course, it must also be taken into account that not only the owner, but also the exclusive licensee, and by the way, in case of shared patent, the co-owners of the patent can sue for infringement. For non-opted out patents, therefore, it is absolutely advisable to expressly provide, in the context of the license agreements or on the context of the co-ownership agreements, or with side letters supplementing them, the strategy to be followed in the face of infringement. That's extremely important. And also vice versa, in case of actions brought by another party who asks for the revocation of the patent. It is always very important in order to favor the share of the patent, the licensing that in many cases may be a great opportunity from a business point of view for companies for using at it most the potential economic strength of the patent. In this respect, it should not be forgotten that the pendency of a revocation patent action is, in our legal systems, prejudicial to an action for the infringement. In Italy, the Supreme Court of Cassation stated in a famous decision that it gives to a necessary stay if the infringement actions on the merits. Of course, the situation before the UPC is different when it comes to the case of pendency of a action before the central division and of a infringement action before the local or regional division. And by the way, in this respect, you know that it was very important to say that the evolutions of the rules of procedure gave rise to a rational way of as I can say, tackling with the issues that could crop out from the cases where bifurcation took place. In particular, with the rule according to which the final hearing to be held before the central division of the revocation of a patent should be coordinated and take place first with regard to the action before the local or regional division of infringement, in of coordinating the two actions in a very practical and efficient way. But we have also to consider the case for patents that have not been opted out, and of course without unitary effect, that there is a case of pendency of a revocation action regarding one single national part of this patent before national courts and a case for infringement pending before the UPC, and even a further revocation action for the same patent before the central division, the UPC. This topic was specifically addressed in the mock trial that took place in Paris on the 21st of November 2022, few months before the entering into force of the system, where the panel was chaired by our distinguished friend, Dr. Grabinski, now the chairman of the court. Frankly speaking, the solution he and the panel envisaged in that case is, from my point of view, extremely practical, efficient, and absolutely to be recommended. He pointed out that the so-called carve out of an action pending before the central division concerning the European patent at the issue should be considered when, between the same parties, an action for revocation of a single portion of the same patent has been started first. but if I'm not mistaken, in that case was also pointed out that this carve-out not only should be considered imposed in this case, but could also be useful when the decision of the claimant for revocation before the UPC expressly limits its action, excluding a single country or more than a single country, exactly as it happens for a European Union trademark, according to the case law of the European Court of Justice. It may be useful, of course, in some cases. And what is more, we have to consider the case that there is the need to coordinate the actions pending for a non-opted out European patent between national courts and the UPC. While the case is crystal clear in the UPC system, it may be a little bit more complex when also national courts are in charge of this case. Because in the latter case, of course, we should assess during, of course, the transitional period the case on the basis of the rules of the Brussels I regulation, which, however, seems to indicate that if a national fraction of a European patent is the subject of two actions with the same limited to it, or could at least in jurisdiction where bifurcation is not allowed, there is no provision for stay the infringement proceedings waiting for the decision of a prejudicial case concerning the of the patent. Instead, Article 30 of the one regulation seems to indicate that it would be for the national court of the member state before which an action for invalidation of the corresponding national fraction of the European patent, in respect of which an infringement action is already pending before the Unified Court, for instance, to stay the action, or better still, to declare itself lacking jurisdiction on a plea brought by a patent owner, since there is no doubt that the Unified Court would have jurisdiction to hear that invalidity action. The latter solution, I believe, should be encouraged, as it may be easier to coordinate the action and again to favor the competence of the UPC in respect to the national court. As a conclusion, we are facing a time of necessary rethinking of the enforcement strategies of patent owners, as well as the defense strategies of suspected infringers. And this will require even closer cooperation between companies, patent lawyers, patent attorneys, in order to be always prepared, as speed of reaction and the correct approach to litigation, and before that, the correct contractualization, as I can say, of license and co-ownership relations are an absolute priority. And last but not least, let me say that we need also to coordinate with our British as I can say, colleagues. Yes, the UK, due to the Brexit, stayed out of this system. But it's absolutely necessary that we go ahead in talking with them, go ahead in trying to find shared solutions, especially from the substantial point of view. I mean the rules of interpretation of the patents and of the scope of protection of the patent. As a conclusion, we can say that, in my opinion, the most significant achievement of this court should be a definitive end of the dangerous illusion of the national road to the patent litigation from the substantial law point of view, deleting also what we know of the idea that the validity and the infringement shall be assessed pursuant to different criteria from those resulting from the EPC experience, and I think especially the Board of Appeal of the EPC experience, and for equivalence from the Protocol of Interpretation of Article 69 of the European Patent Convention. This further progress in terms of certainty of the law will most likely be the most important result if we altogether will work until this result has been achieved, both for the patent owners and for those accused of infringement, often innovative companies as well, of the new system of the unitary patent and of the unified patent court. Thank you very much.
Thank you, Professor Galli, for your interesting contribution to this meeting today. And now we have 3 speeches of about 5 minutes each from associazioni di categoria nazionali, directly involved in the business field or technical innovation of the Unified Patent Court. I mean in particular Farmindustria, Federmacchine and Confindustria. I will leave the stage now to the president of Farmindustria, Marcello Cattani, that is online. Here I am. Hello.
Hello, and thank you very much to the Honorable Chamber Member Simone Billi and the other authorities today on this important meeting. And please, sorry for my logistic situation because I'm commuting in a travel. So for us, for the pharmaceutical industry, the clear step forward related to the current UPCA in force is quite significant in a way to rationalize the litigation processes, and so parties involved do not need to engage in parallel patent litigation in the different member states, and save time. With a simpler, quicker, and more efficient judicial procedures, and for the effectiveness for decisions automatically valid in all European states that have joined the agreement established in the UPC court. Of course, related to the pharmaceutical industries, we have at one end a political situation today managed by the Commission related to, I would say, a much more action on the patent protections that are in 2 fields, which means the regulatory data protections and the market exclusivity authorization. And in that perspective, the current vision of the Commission is quite negative, which means ideological wise, in order to reduce those protections and timelines, which means for the European industry to lose competition, the ability to compete with China and US mostly in a way that China, last year was working in order to enlarge and protect more the patent, reaching a very stable field of competition with US companies. And there is again a wish in our hands as a pharmaceutical industry operating at one end. We are hoping that in 26 when there will be a revision.
Scusi Presidente, un'osservazione, scusi, l'abbiamo persa per l'ultimo minuto, gli ultimi 60 secondi, probabilmente a causa della galleria.
Sì, provo
gli ultimi 60 secondi.
The camera in order to save much more network broadband.
Sì, a partire da quando accennava al wish del pharmaceutical industry.
Okay, our wish is as the strongest pharmaceutical industry across Europe is to work in two directions. The first one is, of course, thanks to the new elections in the European Parliament coming on next June, to have a substantial review from the directive and the regulation related to both the matters, which means regulatory data protection and market exclusivity for drugs, in order to reestablish, long timelines of protections, and so reestablishing the ability for European industry to secure R&D investments and to grant to the European citizens more innovative drugs and drug production and manufacturing sustainability to European countries. The second wish is to wait till 26 to review, the current range of competencies related to the Unified Patent Court, because today, for the pharmaceuticals, the skills and competencies are split between Part Milan, Paris, and Munich courts, which means we can make a step further and better in order to unify all the competencies, including those related to the SPC, the supplementary certificates protection, under one court. This will speed up again the ability to save time, to centralize actions, and in the end, the ability to protect the European companies' competitiveness, saving times, saving monies, and making actions much more easier and suitable across the Europe states. And so, thank you very much for this time to attend this meeting, and I'm fully available if you need more clarification or there are questions related to pharmaceutical industry.
Thank you, President Cattani. My suggestion is, if there is anybody of the speaker that want to add any comments now from the speech of Cattani, please let me know. Otherwise, we will move, because I know that Federmacchine and Confindustria has some question, and maybe we can discuss all together at the end of these two additional speech. So please let me know if anybody wants to add something to President Cattani of Farmindustria. Okay, so we can move. So please, I see Bettelli already connected, Bruno Bettelli, the president of Federmacchine. So please, President Bettelli, the stage is yours. Thank you.
Thank you, honorable deputies, ladies and gentlemen. But first of all, let me apologize for not being there in person. I would thank Honorable Simone Billi and all the speakers and the attendants. In a world where technology and innovation serve as a driving forces of progress, it is essential to ensure an environment where creative minds can thrive and advance ideas that will transform our lives for the better. In my view, Unified Patent and the Unified Patent Core are pivotal milestones in this direction. They represent fundamental tools for achieving the goal of a Europe where borders are not obstacles to innovation, but rather launching paths for a shared success. The Unified Patent will allow us to create a more favorable environment for investors, small business, and startups for eliminating the complication of obtaining different patents in each European country. Meanwhile, having a unified court operating impartially with shared rules will place all stakeholders in a position of legal certainty and equivalence, regardless of their location. We must construct a system that rewards creativity and entrepreneurship, not one that hinders them with bureaucracy and financial obstacles. This initiative will not only streamline the patent application process, but also reduce costs, enabling anyone with a brilliant idea to pursue it and, most importantly, protect it without facing insurmountable financial barriers. However, Unified Patent will promote knowledge sharing and cross-border collaboration. The brightest minds know no boundaries, and the Unified Patent will allow us to calculate an environment where ideas can flow freely from one European country to another, fueling a virtuous cycle of innovation and progress. In addition to all mentioned benefits, the Unified Patent brings significant advantages for small and medium enterprises. The lifeblood of the European economy, representing the backbone of the instrumental goods sector represented by Federmacchine and encompassing by the majority of our users. I expect, therefore, that Unified Patent will radically change this landscape, offering small-medium enterprises a smoother and more accessible path to protect their innovation. By reducing cost and simplifying procedures, small-medium enterprises will be to systematically utilize the patenting tool, which has not been a foregone conclusion thus far due to the inherent difficulties we have mentioned. Furthermore, companies will finally have a tool that allows them to quantify their knowledge in terms of intangible asset, increasing their value and market attractiveness. This will partly circumvent what often represent one of the main obstacles for small-medium enterprises, namely access to the capital markets, by allowing the use of solutions previously used either by startups such as venture capitalists or by the large companies' investment funds. Additionally, the Unified Patent would enhance the competitiveness of small-medium enterprises in a global market by eliminating the need to obtain separate patents in each European country. Small-medium enterprises could more easily expand their operation throughout the European Union, reaching a broader audience and fully leveraging the potential of the European single market. However, it will be crucial for this tool, beyond its principled statements, to be generally accessible for business, especially in terms of cost. Despite the percentage reduction of fees for micro and small companies, but not for the medium ones, probably those for more involvement in IPR protection issues. It would not be acceptable to envisage a situation where the expenses for supporting a case before the Unified Court reaches unsustainable figures in the hundreds of thousands of euros, also considering legal fees for a company, especially a small one. This would create a content where small medium enterprises could not protect their rights as they would not have the necessary financial resources, or worse still, could be cornered if challenged by a stronger, financially endowed entity, albeit a possibility in the wrong. It should also be considered that typically for the small medium enterprises, this is not necessary to protect its know-how in all the countries that are part of the Unified Patent Agreement. This means that they will not have the cost advantage that the unitary patent offers compared to filing on a country-by-country basis. Let us support and promote the unified patent, not only to foster innovation and collaboration, but we have also to ensure that they facilitates a conducive environment for small medium enterprises, which are the backbone of our economy and the engine of our prosperous future, also supporting them under their related financial aspects. I'm also confident that the establishment of the Italian branch of the Unified Court and the definition of appropriate operating rules will represent a significant steps in this direction. So, I will have some questions. I don't know if it's the right time or if I have to postpone later.
Yes, please.
So, my first question is, many Eastern European countries, a part of Bulgaria, which represent interesting markets for Italian exports, as well as Spain, a competitor in certain sector of capital goods, are not yet involved in the Unified Patent Court mechanism. Are there any indication regarding their involvement and their related timelines?
Okay, this is the first one. Then maybe you have also
Yes.
additional question. Please, thanks.
The second one, what recommendation can be offered to companies that already hold industrial property titles to benefit from the advantages derived from the unified mechanism? And last but not least, do you envisage in the future and in the either national or European level the possibility of facilitate the active use of the shared patent in addition to the already mentioned percentage discount on fees, which is currently only applicable to micro and small enterprises, such as through tax deduction or facilitated credits to cover expenses? Thanks.
Thank you, President Bettelli, for the Federmacchine. My suggestion is to try to reply now to these three questions. Then we will give the stage to Markovina, here in presence today from Confindustria, and then maybe we can reply to some of his questions, and then we will have a question time for the people here in presence. So please, if you want, President Grabinski, thank you.
Yes, first question, Eastern European countries. As I mentioned, Romania is expected to join very soon. So that will be same part of Europe like Bulgaria. Already are a part of the UPC are the 3 Baltic states and Slovenia. And for the other Eastern European countries, there is at the moment no sign. So in particular Hungary and the Czech Republic. So that is, but of course it is also, but it's now becoming a bit political. It's also the question of the general landscape. That's not only, I guess, it's not only patent that matters in that regard. As to the second question, with with already industrial property titles, of course, with regard to classical European patents that have been granted in the past. Of course, the answer is if you want to profit from the UPC system, don't opt out. If you stay in the system, then you can make use of it, and you can combine patent litigation with regard to all these parts of the European patent that have been validated and maintained in one go. So you don't have, for example, if you have validate and maintain the Italian, the French and the German part of a European patent, the UPC, as long as you don't opt out, offers a possibility to bring infringements in all these 3 countries before one court, rather than having to go before the Italian National Court, the German National Court and the French National Court. That's the advantage of the current system, already with an existing title. And with regard to the cost issues, I can only discuss, of course, the UPC fees. With regard to taxes and credits, that's more a political issue again. With regard to the court fees, it is a kind of balance. Someone has to pay for the UPC because also judges want to have a living, and of course also the staff and the whole system has to be maintained. Court has to pay for, in particular, IT, but of course also other facilities. So there are some costs that are there, expenses that are there, and they essentially are covered by 2 sources. The one source are the fees, including, in my concept, but maybe some members of the administrative board have a different view on this, but in my view it is, on the one hand, the proper court fees that go directly into the budget of the court, but also the fees that are generated by unitary patents that go directly into the budget of the member states, so they get money from the system. That's the one thing, and the other thing is that of course that everything that is not covered by this has to be paid by the taxpayer, like any other court. So it is not completely new that courts are not normally regarded to be self-financing. The objective of a court is not to make money, but it is to make a law happen and to be realized, and that of course is also part of the general aspect of tax paying. So having this in mind, of course, how this boils down to concrete numbers is of course for the administrative committee to decide and not for me. I would like to leave it there.
Thank you. I don't know if there is any other speaker who wants to add something. Let's say from a political point of view, we can say about credits or fiscal facilitation. For the moment, we are only discussing about such issue for directive for the Unified Patent Court, but we already have, as maybe you know very well, fiscal facilitation for filing patents, trademarks, and so on at the national level, and this is very important. Again, we are discussing on fiscal facilitation specifically for UPC, but for the moment only discussion. So if there is no other speakers who want to add something, you can move to the next speaker, as I told you before. Sorry? Professor Galli, want to add something? Yes, please.
Just for the sake of completeness, I must say that the full use of the potential of patents from the contractual use of it I mean that it's really important that patent owners understand through the contract, through licensing activity, through sharing contracts regarding the use of a patent without their core business, they can obtain a leverage effect that the system of the UPC does not contrast in any way. Instead, it favors it from my point of view. However, it's strictly necessary to think about it in a strategic way. Instead, as for the issue of costs is concerned, please consider that in the 3-year plan for the development of international intellectual property in Europe, considering the strategic value of intellectual property, especially for small and medium businesses, it is expressly indicated the, as I can say, move together the encouragement of these companies to use the patent system. Therefore, I think that it is up to the new European Parliament think about the possibility of stretching the actual facilitation for micro businesses also to small and medium entities, also in regard to the UPC system. However, it will depend in the large part on the success of the system. In other words, if we are able to convince, especially the great entities, to believe in this new system and therefore to encourage them to promote, to bring actions before this system and in such a way to let it to be able to auto-financing, that from my point of view will be make easier for the European policy to extend to small and medium entities these facilitations. In other words, it is up to us. It is up to the business in Europe the possibility of exploiting at the best the new opportunities of the system.
Thank you, Professor Galli. I don't know if President Bettelli wants to quickly reply, or even President Cattani for Farmindustria, if you want quickly reply. Otherwise, we can move to the next speaker. Thanks.
It's okay.
Yes. Okay, so thanks Paolo Markovina, the representative of Confindustria, here in person today. Again, thanks to him for being present and his availability today. Please, the stage is yours.
Thank you, Honorable Billi. And let me also thank Professor Galli, because he really talks like a man of the industry. Many of the arguments he has presented are really shareable from who works directly in the industry. Let me introduce a bit what I was tell now. I will present some arguments on behalf of Confindustria. Let me anticipate that these arguments are not to be seen as a criticism to the existing system, in particular to the system in Europe, but as a way of starting a discussion for the future. So what can be done next in order to improve the system in Europe? So Confindustria has supported the project to create a unified European patent protection and litigation system from the beginning, and even in the most critical phases of discussion, has always encouraged the Italian government to join the system. There is therefore full satisfaction with the start of the system and the assignment of a section of the Central Division in Milan. Even if we hope that the jurisdictional competencies on all the matters initially assigned to London, as defined in the agreement signed in 2013, can be assigned to Milan in the future, possibly soon. The current European patent litigation system, strengthened with the introduction of the UPC, offers a considerable number of options to those who want to assert their rights, whether it concerns the rights of patent owners or the rights of those who, in good faith, intend to freely use their technologies. When a legal resolution becomes necessary, the choice of the best attack or defense option can be difficult, being linked to numerous technical, legal, commercial, and competitive factors. However, as also anticipated by Professor Galli, this choice is made even more complicated by the complexity of the current system, made up of the already existing national systems, which are different from each other, and of the new unified system. The latter, in addition to being itself different from the national systems, has yet to complete its development, because it still only partially covers the European territory, presents a transitional opt-out regime for classic European patents, and has not yet developed a consolidated case law. This last aspect seems to be the main cause of an apparent prudential attitude towards the use of the UPC by Italian companies, which still seem to rely on the better-known national systems, waiting to see which direction the new UPC system intends to take. It is also clear that this complexity can be particularly felt by SMEs, which have less ability compared to more structured companies to develop valid litigation strategies to deal with the risks and opportunities of the overall system and to exploit the advantages offered by the UPC. Therefore, although the UPC has in itself introduced a particularly effective system of litigation, and although the Enforcement Directive of 2004 has already led to a certain alignment of national enforcement practices in recent years, there is the impression that the industry feels the need for a further simplification and harmonization effort, which facilitates the choices of innovative companies, especially small ones. Among the aspects on which greater harmonization is hoped for, there are, for example, those linked to the granting of provisional measures, such as the types of possible measures, the time for obtaining them, the granting of ex parte measures, the use of protective letters, the urgency criteria, the presumption of validity of the patents, and the need to follow up with proceedings on the merit. Other relevant differences are noted, for example, in terms of duration of the main proceedings, qualification of judges, possible bifurcation, and quantification of damages. And there are also other differences which have been highlighted by Judge Catallozzi. But apart from the harmonization aspects, it is considered as highly important that the UPC develops a case law based on uniformity of judgment, for example, between the different local divisions and regional divisions, and balance of interests. Moreover, to create a trust towards the quality of the new system, it is important that a certain harmony of judgment is created between the courts of first and second instance of the UPC to avoid the criticism which is unfortunately present today towards the work of the EPO when considering the number of decisions of the opposition division overturned on appeal, higher than 50%. Finally, in order also to enhance legal certainty for all users, it would be desirable that the UPC adopts as far as possible the consolidated approach of the EPO towards certain aspects of substance, such as the analysis of inventive step, the interpretation of the claims, the evaluation of added subject matter, and the admissibility of new evidence in appeal procedures. To summarize, we believe that there is a need to reduce the existing complexity and to work towards a greater harmonization, and we hope that the UPC could be the driver of such process thanks to its well-designed procedures and by developing a uniform and balanced case law. Thank you.
Thank you, Markovina. If I understand correctly, no question, right?
I expressed a number of points here which could be open to questions or so, but I don't know if we have time.
Yes, President Grabinski said that he wants to quickly reply to your comments.
Yes,
Thank you.
Mr. Markovina, I think it was a very interesting speech and you raised a lot of points. I probably cannot cover them all, but just to give a kind of perspective, I think the first step is, of course, we are now in months 10, 11. So there was not much time to build, develop a case law, but we are already starting this. There are decisions from the Court of First Instance, different divisions, and there are also already decisions from the Court of Appeal. And these are the first steps to develop a case law. For example, the Court of Appeal dealt to some extent with claim interpretation. And also cited in that context a decision of the enlarged Court of Appeal. And so it is clear that there has to be developed a case law within the Unified Patent Court and as harmonized as possible. That's the first step. And of course, the Court of Appeal plays a major role in this, but not only. Of course, also the Court of First Instance. They take note of decisions from other parts of the Court of First Instance. So one local division from another local division, or of the central division, or of a regional division. And it is the aim to make sure that as everyone speaks English, but not everyone speaks German, not everyone speaks Italian, not everyone speaks French, that these should, as far as possible, should be translations from decisions from these languages that are not spoken by everyone into English, so that there's transparency as to the case law. I think that's the first step. And then, of course, this sent for the different panels to see, okay, what has another panel already decided in that regard, and should we follow or not? No one is bound to follow, but of course there is, as this is called, persuasive influence. And then, of course, if there is a discrepancy from one case to the other, that of course would then be will go up to the next level, and then it would be for the Court of Appeal to settle the issue. That is the perspective within the system. And then now, outside the system, we currently have, of course, the national courts, and we have the EPO, in particular the boards of appeal, but also, of course, the opposition boards. And in that regard, the UPC has no binding authority. It is again about persuasive authority. And there again, it is, I think the UPC plays a particular role because it is not only a court of one national, one country, but of 17 countries. But as said, we will see to what extent the UPC then is influencing the other the EPO and the national courts, but on the other hand, of course, also when the UPC is developing case law, they will look at what happened, what is already there, what case law is there from the EPO, what case law is there from the national courts, and at the end, it should, I think, from all sides be if possible, a pro-harmonization approach. And then you may even see it at the moment already happening to some extent. It's very open, but still you may see it happen with regard to claim interpretation. That's one aspect, and we will see to what extent this will develop also to other aspects when the court will get there. So that is in general the perspective. With regards to the coexistence of the national courts and UPC, as mentioned, if the patent is not opted out, the situation is that you have, as also explained by Professor Galli, you have a coexistence, a parallel competence jurisdiction of the UPC and the national courts. And this it was a political decision to have this during the transitional period, which will at least be 7 years from 1st June of last year. Maybe prolonged, but this is very open at the moment, of course. And once the transitional period has been finished, then it is no longer a coexistence. Then it is only the UPC will have competence for European patents. And why has this transitional period, was it decided to be a good idea? It is in order to allow those who are not satisfied or want to wait still stay in the old system, but those who have confidence, who want to shape the new system, be part of the new system. So that is a kind of optional situation, and I think it is a rather good one, because if we would have forced everyone to decide from one day to the other, either you stay in the old system or you go to the new system, then of course it would be much more problematic. So everyone can now decide, okay, what is preferred and where's the confidence. And finally, also the UPC is not starting from the scratch. It is the judges are not beginners. They are, most of them are experienced judges, and they are now in the new system, but at the beginning also most of them only part-time, as was explained by Massimo Scuffi, and so that is, I think, also an aspect that should be taken into consideration. So it is not, don't expect something really surprising in that regard, but it is a continuation process, and the UPC profits from the experience of the judges that are in the system. I hope I touched upon some of your aspects. Thank you.
Okay. Prego, Scuffi. Prego.
One opinion about a couple of this point read. It's interesting, the relationship because between the UPC system and national system. Can we expect national code of procedure to be amended, to be provided for panel of judges include the technical qualified judges as representation? It's difficult, this problem, because in Italy, for example, the patent disputes are entrusted to the ordinary jurisdiction, governed by full-time and exclusive legal judges who have to pass a public competition. So, when you discuss about validity, about nullity, yes, maybe that the patent attorney is just entitled for the defense, maybe also called to decide this particular question, this particular litigation on validity and nullity. But when is involved the compensation of damages, I mean, so all the problem of the infringement, I think it's difficult at the moment that the technical judge can, I see, govern, yes, an ordinary proceeding. So, because in Italy there is a rigid selection for the ordinary jurisdiction. The second is, as is similar, can national patent litigation probably be expected to be changed by national legislators to harmonize with the UPC? Yes, but harmonization is a long process. But some innovations brought by some rules of UPC have been introduced in our domestic legislation. For example, I remember the recent double patent protection, double patent processo. I think this is a system that is necessary, and an alternative action should be provided for avoiding the so-called double jeopardy. So it's not perfect, maybe some to adapt this, but we are free. The UPC rules that it is free for the country to decide double or not double protection. We have only one protection now, is double protection, but I say double protection there are many problems, you see, to avoid something like nebis in idem, I mean, not for the double protection. Second, we introduce the safety net solution. So, safety net solution is introducing an extra deadline when the unitary effect is rejected, and the term for the European patent validation has expired. And in this case, the 3 months have a long duration, a more long duration, just to cover the problem of expiration of the European patent validation. And then the most important innovation is the introduction of indirect contributory infringement. And the contributory infringement, it was in the past always recognized by the Italian case law, always, but now is in positive. There is a positive rule in which it is a positive rule to rule exactly all these cases for the example of UPC, because in UPC are provided also mechanism, yes, to fight against these particular infringements. So these are innovations that we have in our case law. We are in our code of intellectual property code, and they are important. And maybe in the future you have always new harmonization. It's impossible to have a total harmonization of all, but are the little steps, yes, to be to have an equivalent also in the national procedure, and so to contribute to the certainty of the right. This is important because you have two systems, but you have to avoid that there is a conflict to this conflict. See? Yes.
Thank you, President Scuffi. If there is any other comments, or maybe I saw from the public, Andrea Scilletta. Thanks. Thanks, please, Andrea. Maybe you can introduce quickly yourself, I think. Thank you.
I'm Andrea Scilletta. I'm technically welfare judge of the UPC, but I'm not talking on behalf of the UPC now. I have two very short questions. The first concerns a significant part of the speech by Mr. Galli, and I would like to ask to Mr. Grabinski is, if he has heard about any claim in infringement actions of the UPC covering also an injunction or an application of provisional measures covering non-member countries, especially EU non-member countries. And the second one is for the lawmaker, but I would like to hear about, for instance, Mr. Catallozzi, a comment on this. It is true that there is a strong harmonization, but it has to be built between the national law and the UPC. Let us just think about the infringement action. The authentic text before the UPC is the one in the language of proceedings. In Italy, we have the same, apart from the case where the translation into Italian defines a more limited scope of protection, in which case the scope of protection is the one more limited compared to the one issued by the EPO. So my question, or I would like to have the opinion of Mr. Catallozzi, if it would be advisable to change our law in order to make the translation into Italian just as an informative translation and not a substantial definition of the scope of protection.
Okay, thank you. What do you think, President and Speaker? Can we have maybe a couple of questions together so we can speed up? What do you think, President Grabinski? Maybe can we have another question? Maybe. What do you think? Okay, prego. Thank you.
Yes, thank you. Elizabeth Paolo, I'm also a TQJ, but I'm not talking as a TQJ now, but as a member of the Ordinary Consulenti. If I may, I have a general comment about the speech from Mr. Markovina and then a question. My comment would be, first of all, thank you for focusing so clearly the main points that might be of interest for the industry, which of course is the main users of the system. As we all know, the objective of the UPC, and particularly stated also in the preamble of the agreement, is to obtain harmonization and uniformity of interpretation. If we look at the first cases of the UPC, and particularly the first orders and the first procedural decisions that have been taken, I think we can agree that the principles that are stated in the interpretation, the way the rules have to be interpreted, particularly flexibility and proportionality, have been kept by all the panels. And we can also see that all the panel speak together, meaning that they refer to one another in the decision. So I don't think that we can really see a risk that there is a lack of harmonization or uniformity within the panels of the UPC. And we have also seen that each time there was an issue that actually required interpretation also on the procedural side, the panels of the first instance, they just decided to leave to appeal in order to allow the courts of appeal to decide also those issues as fast as possible, so that for the confidentiality issues, for the definition of the terms. So if I may make a personal comment, I think that the first steps of the UPC can reassure a little bit about this risk of disharmonization. And then the question is, we're talking, many of you are talking about Article 83 and the provisional, the transitional period. What I would like to ask is whether there are any statistics already about a decrease in the national litigation concerning the European patents now that the UPC has come into force, particularly in Germany, for example, where the majority of the cases have been filed.
Okay, thank you. So I think President Grabinski, maybe if you want to reply to...
There's only two questions for me, to my understanding. That's good. The one from Mr. Schiletta. What about decisions in infringement cases that go cross-border? So, for example, with regard to Spain, just as an example, as a EU member state that is not part of the UPC, and I think the situation is the same as it would be with an Italian court or a German court or a French national court with regards to decisions on infringement with regard to Spain, in my example. It could also be, of course, Croatia or Poland or whatever. In that regard, the Brussels 1A regulation applies. And to my understanding, it can be that there is a competence, for example, with regard when the defendant is a German company, and it is about suing the German company for infringement in the UPC countries, but also in Spain, of a European patent that has been validated and is in force and is maintained. That the court in principle is can against such a defendant has a jurisdiction to issue an injunction also with regard to Spain, but as soon as the defendant then raises the issue of validity of the Spanish part, then the UPC would not, like an Italian court or like a German court, would have no competence according to the case law of the European Court of Justice, Gatluck case, and therefore then the UPC, like the Italian court, would either has to stay proceedings and wait for the decision of the Spanish court on the validity of the Spanish part of the European patent, or even say we have no jurisdiction at all. Which of these two reactions depends. There's currently a case pending before the CJU that is dealing with this issue, so we have to wait and see what the CJU is deciding on this. But so, to that extent, it would be possible or not possible for the UPC to have a decision with regard to a non-UPC country, but also mentioned already today is the Solvay decision in preliminary injunction cases, and there it is a bit more liberal. There it might be a bit easier for the UPC to also have a decision with effect to a non-UPC country like Spain. And the second question was about the effect of the cases that now are brought before the UPC. Do they affect the number of cases before the national courts? And as far as Germany is concerned, I can't give you statistics on this, but I heard from several sources, yes, there are less cases before the German national courts than that have been before 1st June of last year.
Just probably I miss something. You advocate for an amendment of the national legislation. Yes, in order to what extent the language?
In order to avoid that the national the translation into Italian of the European patent takes the lead.
Yes, I think that all the national practice should be. I don't know if it is. I'm advocating for an amendment of the Italian legislation. I think we, as judge first, have to be accustomed to work in English. And as far as I see, as my brief practice at UPC at the Paris Central Division, which we deal with revocation action, more than 90% of the patents that have been attacked with the revocation action are in English. So I think that, or by the way of best practice, or by the way of an amendment of the Italian legislation, I think we should assume English as a default language for a claim construction, assessing on the validity of patent or infringement. I think, the parties will provide maybe with a translation, but I think the more we push, it's something that I'm thinking. I'm speaking with regard to the judges, background should be in English should be included. That's something that I'm saying. suffering, because a lot of time I got in contact with very good colleagues, very experienced patent law colleagues that could not, I'm not saying reading a patent in English, but also speaking, reading in English. And that's a pity. So I don't know if the right solution is to have an amendment of the legislation or not, but that should be a legislation in order to, a practice in order to reach an harmonization of the patent protection in general. And also, I hope that by the way of translation or whatever, also UPC could use more frequently or the English language, so that every judge may, well, the communication, the circulation of judgments get easier.
From my side, Shileta, I can say I can get your comments as an action item. So let's work together with Ordine, the Consulenti Pura Industriale, and all the other professionals in order to improve the UPC law and the national Italian law together, to harmonize and to improve in order to work better on such legislation.